All right, pause here. This isn't just another routine court hearing. This is a conditional release revocation, which means someone who is already released is now at risk of being sent back into custody. The stakes? Huge. Freedom versus confinement. And by the end of this hearing, you'll hear a decision that changes everything.
All right. The court calls 2014 CF 596, State of Wisconsin versus Morgan Geyser. Can I have appearances, please?
Abby Nikolai appears on behalf of the state. Good morning, Judge.
Good morning, Judge. Morgan Geyser and Attorney Anthony Cotton both appear by Zoom from separate locations.
And good morning. We also have a DHS representative on the line. We are here to discuss the petition for revocation for conditional release that was filed on November 25th. And in particular, Ms. Geyser's stated intention not to contest the petition for revocation of conditional release and waive the evidentiary hearing on same. Just as a matter of what I think is undisputed, Mr. Cotton, there's no dispute the petition to revoke was timely filed under the statutes. Is that right?
Correct, Judge. No dispute.
All right. And by way of background, just to catch us up, Ms. Geyser was previously found not guilty by reason of mental disease or defect in October of 2017. In February of 2018, Judge Boren sentenced Ms. Geyser through an order of commitment for 40 years. On January 9th of 2025, Judge Boren deemed the conditional release was appropriate and entered an order that she be conditionally released. And while it took a while for the conditional release plan to be developed effectively, the actual conditional release plan...
This part is critical. When the judge cites Wisconsin Statute 971.17, that's the legal framework for people found not guilty by reason of mental disease or defect. Conditional release isn't freedom. It's supervised liberty. Violate the rules, and the court doesn't need a new crime to step in.
It was finalized in September of this year, and after certain events occurred, the DHS filed a petition to revoke Ms. Geyser's conditional release on November 25th of 2025, and that's what brings us here. In that petition, the DHS alleged that revocation of Ms. Geyser's conditional release is appropriate under WISTAT Section 971.173E, and the state contends that both the conditions of Ms. Geyser's conditional release were violated and that remaining on conditional release would pose a risk both to her own safety as well as the safety of the community.
Now here's where things take a sharp turn. The defense isn't fighting this. No witnesses, no arguments, no evidentiary hearing. That's not common. And it raises a big question. Is this a strategic retreat? Or does the evidence make contesting this too risky?
The allegations include, and I won't go through them all, that Ms. Geyser fled placement, cut off her GPS monitor, and committed other violations of the conditional release order. In support of their petition, the state has alleged, the DHS has alleged, that Ms. Geyser violated the rules for conditional release, and under the circumstances, her release would involve a continued heightened level of dangerousness if she remained on conditional relief, both to herself and for others. In my understanding now, based on Attorney Cotton's earlier correspondence, is that Ms. Geyser intends to waive any objection.
Notice the phrase clear and convincing evidence. That's a higher standard than probable cause, but lower than beyond a reasonable doubt. And yet, she's waiving the hearing entirely. So let me ask you, if the state had to prove its case, would this outcome have been different?
And will not be contesting the petition for conditional release. Is that right, Mr. Cotton?
That's right, Judge. I spoke with Ms. Geyser at length about this decision, and we don't intend to challenge the revocation.
Okay, thank you. I just have a few questions for Ms. Geyser just to make sure she's making this decision freely, intelligently, and voluntarily. And Ms. Geyser, you've had a chance to review the DHS position for revocation of conditional release?
Yes, sir.
Okay, and you've been able to review it with your counsel, and he's answered any questions you may have had about it?
Yes, sir.
And Ms. Geyser, you understand you're entitled to have an evidentiary hearing on the DHS position to revoke your conditional release?
Yes, sir.
And you understand if we had that hearing, it would be the state's burden of proof to show that the revocation of conditional release is appropriate. You understand that, ma'am?
Yes, sir.
And you further understand that the burden of proof the state would have to face is to prove that by clear and convincing evidence.
Yes, sir.
And your counsel, for you, waived the 30-day time limit for having that hearing on your behalf, but we currently have a hearing set for February 16th, 2026. Do you understand that, ma'am?
Yes, sir.
And if we have that revocation hearing, you understand you would have the right to be represented by counsel, is that correct?
Yes, sir.
You'd have the right to see and hear the evidence the state presents at that hearing, is that correct?
This is the point of no return. By waiving this hearing, the court no longer has to prove anything. No GPS evidence. No witness testimony. No cross-examination. The consequence? Immediate return to inpatient commitment. This is how rights quietly disappear by consent.
Yes, sir.
You understand you'd be able to present evidence and witnesses on your own behalf, is that correct, ma'am?
Yes, sir.
And you understand you'd also be able to cross-examine the state's witnesses, is that correct?
Yes, sir.
All right. And you've been satisfied with the services of Mr. Cotton, is that correct?
Yes, sir.
And earlier on December 16th, 2025, Attorney Cotton provided me with some correspondence indicating that you have elected not to contest the position to revoke your conditional release. And that's true, ma'am?
Yes, sir.
And you are satisfied that you've had ample time to discuss the ramifications of waiving that hearing and the burden of proof the state would have to face if we had that hearing, is that correct?
Yes, sir.
And your counsel is able to answer any questions you might have about the DHS petition for revocation of your conditional release. Is that right?
Yes, sir.
And at this time, is it your decision to waive the hearing on the petition for revocation of conditional release?
Yes, sir.
And you've decided not to contest the merits of the petition for revocation of conditional release. Is that right?
Yes, sir.
And you understand that if you waive your right to a revocation hearing, ma'am, the court will revoke your conditional release in order you return to inpatient commitment or other custody under Section 971.17.
Yes.
Okay. And the state will not have to prove any violations of the hearing, ma'am. You understand that?
Yes.
And you understand that revocation of your conditional release will result in your continued confinement on your NGI commitment, subject to further future review as provided by law. Is that correct?
Yes, sir.
And again, you've had what you believe to be sufficient time to discuss this decision with Mr. Cotton. Is that right?
Yes, sir.
And no one's promised you anything for waiving your right to contest the petition. Is that correct?
No, sir.
And no one's threatened you to make you waive your right to contest the petition. Is that correct?
That's correct.
And you're making this decision to waive the revocation hearing freely, intelligently, and voluntarily. Is that correct?
Yes, sir.
And you understand, finally, by waiving that revocation hearing, you're giving up your right to contest the allegations in the state's request for revocation, correct?
Yes, sir.
And knowing all these rights and consequences, do you knowingly, intelligently, and voluntarily waive your right to a revocation hearing under WISTAT 971-17-3E?
Yes, I do, sir.
Thank you, ma'am. Do you have any questions at all for me regarding your decision?
And just like that, it's over. No trial. No dramatic argument. Just a legal confirmation that the system is stepping back in. Conditional release revoked. Custody restored. The real question now isn't what happened, but what happens next, and whether future reviews will ever tip the balance back toward release.
Mr. Cotton, you've reviewed the petition. Thank you, ma'am. Mr. Cotton, you've reviewed the petition for revocation of conditional release and related documents that were filed by DHS?
You have your honor.
And you've had an opportunity to discuss the petition and related documents with your client?
Yes.
Are you satisfied she understands the state's burden, legal standards, and other ramifications of her decision not to contest the petition for revocation?
Yes, we've discussed it in detail.
Thank you. And you've heard your client indicate she wishes not to contest the state's petition, correct?
Yes, I heard that.
And you've reviewed this waiver with your client, and you believe she understands the rights being waived and is confident to make this decision?
Yes.
Based on your discussions with your client, is it your belief that Ms. Geyser is making the decision not to contest the state's petition for revocation of her conditional release freely, intelligently, and voluntarily?
Yes, I have an 11-year history with Ms. Geyser, and I'm comfortable with her decision.
Thank you. Ms. Nicolai, do you believe any additional colloquy is necessary?
No, thank you.
Based on my discussion with Ms. Geyser and her counsel, as well as my review of the relevant filings made by the DHS in connection with this petition to revoke conditional release and related filings, the court finds that Ms. Geyser has freely, intelligently, and voluntarily made the decision not to contest the DHS petition for revocation of conditional release and waives her right to a hearing on same. Accordingly, the court finds that the petition to revoke conditional release is meritorious, uncontested, and it is granted. The petition to revoke conditional release is granted, and Ms. Geyser is remanded into custody with directions to DHS to house her pursuant to the original commitment order that was in effect prior to the granting of conditional release by Judge Boren earlier this year. Anything else we need to do from any of the parties?
Judge, I do have the CR 276 that I can e-file.
Okay, and we will take care of that. Thank you. Mr. Cotton, anything on your end?
No, Judge, everything, that was a very thorough colloquy. Everything is fine on our end.
Okay. Thank you all. Have a good day. Good luck to you, Ms. Geyser.
Thank you.